All right, we're going to begin. We're going to hear the case of Ranger American of the Virgin Islands versus Elvis Pedro. And who is going to represent the appellant?
Good morning, Your Honors.
Good morning.
Eugenio Hejel Simonet today on behalf of the appellant.
Okay, and you're going to reserve any time?
Yes, sir. I'll be reserving 3 minutes, if I may, please.
3. Good. And I noticed that you also have just one issue before us. Am I correct?
You're correct, Your Honor. There's only one issue before this
And
court
that's
today.
the punitive damages.
That is correct.
Right, all right, and you say it's excessive. All right, okay, you may proceed.
Thank you, Your Honor. Good morning again, Your Honors. As Justice Swan indicated, that is correct. There is currently one issue pending before this court, which is our appeal on whether the jury verdict's award of punitive damages that was entered by the Superior Court was unconstitutionally excessive, and as a result thereof, whether upholding that verdict and then in a judgment violated the due process rights of Rangers, specifically on the 5th and 14th Amendment of the U.S. Constitution, applicable to us under the Revised Organic Act. Any other arguments before this court are not appropriate, are not proper, specifically as it may pertain to a request to review an error of the judge of the order entered by the Superior Court on the motion for extension. There was no cross-appeal filed, so the only issue is analyzing the excessiveness of the punitive damages, which are analyzed under the 3 guideposts that have been laid out by the U.S. Supreme Court, and this court has also applied to our jurisdiction. In looking at those 3 elements, specifically the degree of reprehensibility of the alleged misconduct, we take that as number 1. Number 2, whether or not there is there's been different words to describe number 2, as a matter of fact. It talks about disparity between the acts or the potential harm and suffered and the actual award. But in addition to disparity, the reasonableness or the proportionality, between that act and the punitive. And thirdly, whether there is any difference between punitive damages and civil penalties or comparative cases, and that's what we focus in on our brief. We respectfully bring to the court's attention, and in this matter, the jury awarded $25,000 on loss of income, 0 award on past non-economic compensatory, and a 0 award on future non-compensatory. Hence, we have a 25, a 0, and a 0, and then, of course, the $275,000 on punitives.
But I noticed you're not challenging the $25,000, which was allegedly wage income. All
Correct,
right.
Your Honor.
You're going with us with just the the $275,000.
The $275,000, that is correct. The only reason for which I bring up the 25 is because it is significant for purposes of the analysis that this court has to entertain, that being the ratio, or the balancing act between what I've just listed out on the guidepost. And it is our position, and it has been all along, that
I don't want to interrupt you, but I always like to make sure that I understand the case very well.
Sure, Your Honor.
And this is what I understand. Mr. Pedro was a full-time territorial court marshal.
Correct.
Am I correct? At the
Public
time,
employee.
in
Yes, sir.
1998, he was a full-fledged employee. And he would work for you part-time.
Correct.
But there was no, what we would call, no collective bargaining agreement between you and Mr. Pedro. Am I correct?
That is correct.
There was no contract written or otherwise between you and Mr. Pedro as to how much hours he was going to be hired. Am I correct?
That is correct. The
Right.
hours assigned arose.
Hold on.
Yes.
All right.
I'm not. Sorry.
I'm not finished yet. And there was no annual leave he would get. Am I correct?
That is correct.
And there was no sick leave that he could make. Am I
There was
correct?
no evidence as to that
So he
issue.
was not a regular employee as such, but he was at best a part-time employee. Am I correct?
You are correct. He was working
In
part-time.
other words, you call him as needed. And the as needed was, you had a lot of clients, some of them money clients such as Pueblo and Kmart.
Correct.
And Kmart, of course, would be a money client. And but all of the money client reserve the right to request whether we have an armed guard or an unarmed guard. Am I correct?
You are correct.
Okay. So that for all intents and purposes, and of course you would go by the dictates of your money client, whether Pueblo or Kmart. By the dictates, I mean, if either of them or a money client does not want a particular marshal or part-time security, whether it be police or marshal, you wouldn't assign that marshal there at all. Am I correct?
If I may address that point, Your Honor, somewhat correct, and if I may explain. And there was extensive testimony and evidence presented at trial on this issue. As you will very well indicate, it was what was termed the operational needs of the post, meaning what is it that the client is requesting in terms of a security guard, be it armed or be it unarmed.
Right.
There is no difference in terms of whether it's a VIPD officer, a marshal, or a full-time. It's just the schedule is based on the operational needs, and that's what Ranger has to establish in terms of how it assigns guards. If Pueblo requested a guard unarmed, 3 to 9, and then let's say in the afternoon, but an armed guard from 9 p.m. until, let's just say, 3 o'clock in the morning, you can't have the same guard from 3 p.m. to 9 p.m. as the one from 9 p.m. to 3 a.m. because one is being requested being unarmed, the other one requested is armed. And so the significance of that goes to the issue of what you're inquiring in terms of what the case is about. And when we put that into perspective in terms of what our question is before this court, we take that into consideration, but I think most importantly, we must not lose focus of the fact that the question on the issue of punitive damages remains that in this case, it's unconstitutionally excessive because when you put on the balancing ratio table,
Like 10 to 1.
it's 11 to 1, Your Honor.
11 to 1.
Yes, sir.
Well, I was close enough, but not quite, but no cigars. All right, 10 to 1.
11 to 1. Thank you,
11
Justice.
to 1, okay.
And compare that.
Excuse me. Let
Yes,
me
sir.
ask you. Was there any commitment to Mr. Pedro that he will work X amount of hours a month?
There was nothing in the evidence presented at trial that indicated that he would be working X amount of hours weekly, monthly, or daily. Again, it was based, as we were just discussing, on the operational needs.
So basically, it was a contractual employee subject to whatever employment becomes available.
We must bear in mind, Your Honor, that he was not available anytime before 5 o'clock in the afternoon. He was a full-time public employee, government employee in the territorial court as a marshal well, I'll be misspeaking if it's 8 or 9, full-time, 8 hours from the morning until 5 p.m. in the afternoon. So his availability was further limited in terms of what he could provide services to Ranger, which Ranger then had to provide to its clients. So to your question specifically, yeah, he was a part-time employee who was subject to whatever operational needs or availability were provided by the clients.
But in this case, you're not arguing that punitive damages are not warranted. You're saying it's just excessive.
That's right, Your Honor. You're absolutely right. We're not entering into question whether there was, let me put it this way, the fact finder, the jury, made a determination that there was sufficient evidence for punitive damages. What we question is the amount of the award pursuant to the 3 guideposts as an issue of law, and which we bring to the court in terms of our appeal, because it is our position that it is so excessive, even when we take into consideration under the 3rd guidepost any other statutes. There's nothing to compare to this. We mentioned in our reply, I believe it's an original brief, that there are some civil penalties under OSHA and on the Fair Labor Act, but specifically under the WDA, the Wrongful Discharge Act, there aren't any. And if we look at comparable cases, this court ruled in Esperson, and I believe in my reply brief, I compared the two. When we do the analysis in Esperson, it's 3.14 to 1, that ratio between punitive and the actual award, vis-a-vis this case where we have a $25,000 to a $275,000 award on punitives, which makes it an 11 to 1, and that's why it is our position.
And what,
that
the punitive was based upon what actions by your client?
Well, Your Honor, punitive damages pursuant to the definition by the courts would require an egregious act.
Right, and
An
I'm saying,
action.
what were the egregious acts that were committed by your client?
Your Honor, if you ask me, I don't see any.
Well, of course,
I don't see any.
don't expect you to, but I'm saying, what did the jury bring back? The acts?
The only act which I could remotely suspect would be not being placed on the schedule after October of 1998, I believe. That's the only issue. Now, to say that that is egregious or that caused harm to an extent of exposing his health or his well-being as it's required under the definition of the guidepost for purposes of punitives, it's an immense stretch of what egregious or harm that may cause severe harm, an action that may cause severe harm would actually entail. So to your question specifically, there really, I can't fathom anything beyond that. Okay, he's not placed on the schedule. How is that somehow an egregious act? There is simply nothing on the record to demonstrate otherwise that Mr. Pedro had been harmed as a result of any action by the appellant, by Ranger. And I see my time is up, unless there are any more questions.
All right, I think that you reserved 2 minutes, so we'll have from the other side now.
All right.
But basically, one last question. Basically, I'm assuming that you are saying that in terms of this issue of punitive damages, we may go back to the restatement, even though we no longer use a restatement, but a restatement 908 talk in terms of punitive damages. And it has to be something that have to be awarded for the outrageous conduct or reckless indifference of the rights of others that would warrant punitive damages. And, well, you don't have to answer this question. I'll have to ask the other side this question.
All right.
All right, thank you very much. Are you going to reserve any?
I didn't get to reserve time.
No, right.
You can give me extra time, though.
You don't reserve any time, okay.
Good afternoon. Rhea Lawrence with Roden Associates on behalf of the appellee Elvis Pedro, and may it please the court. It's always a great pleasure to fly over from St. Croix to be before you. And in another interesting case, I wanted to start with the untimely appeal issue and then quickly run through our arguments with regard to the merits of the appeal. I know the court didn't have any questions for the appellant with regard to the untimeliness issue, but we do believe that there is a significant issue here with regard to the timeliness of this appeal. Now, the appellant for the first time, Ranger for the first time mentioned that there was supposed to have been a cross appeal filed. That has never been the holdings of this court. We filed a motion to dismiss February 24th, 2025, moving to dismiss this appeal as a timely. Every jurisprudence that I have reviewed has disposed of an untimeliness argument with regard to an appeal, either by a motion to dismiss or in the opinion after it's been argued. But never has this court ever indicated that you have to file a cross appeal. And as the appellee, who was the recipient of judgment in his favor, we're allowed to raise any issue necessary as alternate grounds to affirm the judgment without filing a cross appeal, and the timeliness issue would be one of them. And that's this court's jurisprudence, Davis versus UHP. So one of the reasons why this timeliness issue is important to me and important to the court is because this court has stressed over quite a number of opinions that we don't relax these deadlines willy-nilly. These deadlines are there in order to provide finality, and this is a 25-year-old case. And we need to make sure that litigants, and in this case in particular, Ranger American's explanation of why they were not untimely ran the gamut of all sorts of analysis that just defied all of this court's jurisprudence. And one of the reasons why it's important is because this court has given litigants two very clear avenues to perfect appeals. Yes, one of them is you wait the 120 days and you then file your notice of appeal 30 days after order is being deemed denied. But this court has also given litigants the opportunity to file a premature appeal. You file your notice of appeal early. Let the court know there are pending post-judgment motions. And then, as the court explained in Austin, update your notice of appeal. So I don't believe there's any justification for this court to exercise its discretion here and hear this appeal because we believe that it was untimely filed for all the reasons I've stated here and briefed in our response brief.
But Attorney, didn't the Superior Court grant an extension of time for the appellant in this instance to file a notice of appeal?
Yes, the Superior Court did do so, and as we explained in our brief, the Superior Court did so without any analysis at all. And this, I mean, there's just granted, there was no explanation as to how the appellant's Ranger American met the good cause requirement. This court's rule requires that the appellant show why they're entitled to an extension. The Superior Court provided no analysis at all. This court has repeatedly said that you can't review anything or make any determinations if the Superior Court doesn't explain its decision. And I think that we've argued that the Superior Court's failure to explain her decision here, should render her opinion a nullity. And because it's this court's discretion to hear untimely appeals, it should be properly within this court to look at the the issue anew, as we've raised it now twice in our brief and in a motion to dismiss, to determine whether or not this appeal is actually timely before you. Because
But maybe the Superior Court was satisfied with explanation provided by the appellant. So it felt no need to elaborate.
Well, the explanation provided by the appellant was we missed the calendar deadline. I can't tell you how many opinions we've seen where that has never been a justification for missing deadlines. That one of the more seminal cases out of the Third Circuit was Premier Wine and Spirits versus Raguet, and they were very clear that especially when it comes to notices of appeal, calendaring issues is never a justification for not timely filing an appeal. That was the sole reason why the Ranger American gave for not timely filing this appeal, is because their counsel missed a calendaring deadline. Now, if this court wants to open up the door as that being a justification for missed appeals, I guess this is where the court is going. But if we are going to open the door now.
Counsel,
Yes.
Third Circuit is not more than persuasive, correct?
Yeah, absolutely.
Okay.
Absolutely.
Settle down.
Absolutely.
Thank you. Now, basically, you're asking, your whole argument falls under abuse of discretion against the trial court.
Yeah, well, yes, Your Honor.
It would have to be, that would be your argument, that the court abuses discretion by not, by granting the continuance for Ranger America.
Yes, granted extension, yes.
Okay. And you're stating that the basis of your argument is that they did not provide a rationale for granting that extension.
Yes, that Ranger American's justification was insufficient. A calendaring error was an insufficient basis for granting an extension, and therefore was an abuse of discretion.
And your argument is that that is the only reason that you're aware of why the court granted the extension.
Your Honor, that's the only reason that could, that's the only thing that was before the court in their motion for extension of time. Thank you. Now, I'll just move on from that particular issue because it's fully briefed. And again, I strongly believe that this is not a situation where the court should be relaxing or allowing the Superior Court to relax
Counsel,
the deadline.
I understand. Let's get to the meat of the
Yes.
matter. In the
So-
event that the court find there is jurisdiction.
Yes,
All
thank
right,
you.
thank you.
So with regard to the merits of the appeal, there was a lot of discussion about the status of Mr. Pedro, whether or not he was contract, whatever. I think we need to be clear that there is no challenge here to the finding of the jury that Mr. Pedro was wrongfully discharged.
Counsel, let me ask,
Yes.
what actions by Rangers was outrageous that would warrant punitive damages?
Okay, so that's a tricky question.
No, it's
So-
not. It's a straight
Well,
question.
yeah, well,
It's the
It's the very
question,
merit of the case.
it's the question that I'm waiting for.
well,
because
well, if you-
I am like,
so let me permit me
No.
to, yeah, I'm going to answer the question.
Yes,
I'm like
But-
Justice Willax,
Counsel.
because I went over,
I
I
will.
went over this thing several times, and Justice Willax is making a point that, you know, 908 punitive damages, and so explain to us.
So, again,
Thank you,
No,
Justice
yes,
Willax.
please,
I'm
please,
going to
please
explain.
address the.
I will address
Counsel,
the issue.
Please address the question direct.
Yes.
As to the
So-
actions, thank you.
So, and I have to premise this to make sure I'm leading into it correctly, because first of all, the issue of whether or not Ranger American should have had punitive damage imposed is not before the court. All right, I think we're in agreement. They have not challenged
Counsel,
the jury's
Counsel,
determination.
excuse me. We can dance around the cashew tree forever,
Well-
or we can simply stand up in front of it and answer the question. And it's a very straightforward question.
Well, I'll
One
get
that
to that.
obviously you're trying to avoid.
No, I-
But counsel, not here to argue. Please answer my question direct. What actions done by Rangers qualifies for punitive?
Well, the jury received evidence that Mr. Pedro was, while he was a full-time marshal, he also had to take on part-time work in order to meet his financial burdens. So he was a financially vulnerable person. A lot of public employees actually take on this extra work in order for them to do so. So the juror also received evidence that Mr. Pedro, he testified he regularly was on the schedule for at least 20 hours a week from 1997 until October 1998. There was no break in his employment. There was no choosing, he would be on this schedule here or not. And then all of a sudden, he was not put on the schedule without explanation. And this is a person who had worked for Ranger American in that capacity for well over a year, which is why he was covered under the Wrongful Discharge Act. The jury received evidence that...
Wait, hold on. He was covered under the what act you said?
The Wrongful Discharge Act.
The Wrongful Discharge Act, that's Title 2476. I went through that and was trying to look at what it is under the grounds for discharge. Remember now, he is not a full-time employee. He's a as-needed employee. They call on him when they have work. But where, what in 24 VIC 76 grounds for discharge, under wrongful discharge are you talking about?
That's our point exactly. In order for you to discharge a person and terminate, and this court has already held as a matter of law. Pedro, this case has been, this is the second time this case has been an appeal. And in your first Pedro opinion, you held as a matter of law that the failure to put somebody on the schedule is termination and can be covered by the Wrongful Discharge Act. So we're not really, this is not a re-litigation. Pedro 1, this is Pedro 2. Pedro 1 already held that as a matter of law.
Hey,
That-
Counsel,
Yes.
so if I understand you correctly, the one action so far is wrongful termination because they didn't put him on the schedule, correct?
They fail with
They failed to put him on the schedule.
schedule
Okay,
without
that's fine.
explanation, yes.
All right, what other action did Rangers do?
When Mr. Pedro tried to call repeatedly to say, hey, I'm not on the schedule anymore, I need to be able to, I need this employment, they ignored him. There's testimony from that Robin
Okay,
Rich,
so they didn't put him on the schedule, they ignored him. What other actions did Rangers American do?
he called Miss Robin Richards, finally got so sympathetic to Mr. Pedro's plight that she gave the cell phone number for Mr. Delroy Richards, who was the one who was scheduling the employees. And Mr. Pedro called him, and he hung up the phone on him.
Okay, so let's stop. So we have failure to put on the schedule, they ignored him, and someone calls Mr. Richards' personal cell phone, and he hung up on them. Or Mr. Pedro, excuse me. Mr. Pedro calls Mr. Richards' personal or cell phone, and he hangs up on them.
He
Okay,
spoke
what
to him
else?
and hung up on it.
Okay, sure.
And,
What else
yes.
do we have?
And it was Mr. Pedro's determination that he was being mistreated because he was a marshal and Mr.
That's not part of it. What he thinks is not relevant to punitive. What are the actions by Ranger American? We already have 4 that you've stated. Are there any other actions?
Well, that's at the crux of it, Your Honor. We argued that the 3 guideposts were met, and the 3 guideposts under the,
And I'm going to ask you, are there any other actions by Ranger American that was done?
Your Honor, we think that's enough. And
Oh, I see. Okay.
a jury thought that that was enough in order to, 1, make the determination that punitive damages was warranted. Again, the defendant, the appellant has, Ranger American has been clear.
Did they award him pain and suffering?
Your Honor, but that, no, they did not award him pain and suffering, but
But then what does that do to your argument? If you're saying, if the jury thought that all of these actions was warranted because of what he was going through, according to what my understanding of your argument is, then here you're saying on one side, oh, well, the jury thought that the action that he was suffering because he needed the income, the way how he was treated, etc., but yet they didn't award pain and suffering.
But-
Doesn't that contradict your argument?
absolutely not. This court in Esperson, the U.S. Supreme Court in BMW versus Gore and U.S. versus Campbell, has specifically said there are times when the jury is unable to quantify certain things. So this court is taking the position, your question, and Ranger American's position takes the assumption that the jury didn't award pain and suffering because they didn't believe him or it wasn't there, versus they couldn't quantify it. It was hard for them to quantify. And the court, this
And
court
how does
has
that tie
been,
into the due process argument?
I'm sorry.
How does that tie into the due process?
There is
argument?
no due process violation here for the by the defendant. When the court is,
Why not?
I'm sorry?
Why not?
Because the constitutional guideposts that this court has to follow are very clear. And whether or not the reprehensibility of the conduct is different than whether or not it was outrageous and reprehensible warranting punitive damages.
Well,
That's
what
not
I
up
want
for
you to
review.
answer. That's what I want. What it was so look.
Yeah.
Mr. Pedro is a part-time employee, not a regular employee. He doesn't have a contract, whether written or oral, no collective bargaining unit, no annual leave, no sick leave, and he's being hired on a as-needed basis when in fact that they have work for him. But there were other people competing with him, other marshals, and of course the police department. And Ranger American, it seems to me, reserve the absolute right as to who they're going to assign to Pueblo or who they're going to assign to Kmart. And so, you know, because he's a regular employee for the government of the Virgin Islands.
Respectfully, Your Honor, those facts are absolutely not before the court, because
Well, it is not before the court, but what kind of status of an employee was he? Was he a regular employee or a part-time employee?
Your Honor, he was part-time employee, but he was an employee covered under the Wrongful Discharge Act. The Wrongful Discharge Act, in the statute itself, says that punitive damages may be awarded. So forget about the restatements version of punitive damage and all that stuff. It's a statutory form of damages that a jury can consider in 24 VIC Section 79.
Well, just because the problem that I'm having is this thing about he was discharged, but it seems to me as if that Ranger American was hiring when I need you. I'll hire you when I need you on a part-time basis, not that you were an employee as such, and I fired you.
Well, Your Honor, and
which is a vastly different thing.
Well,
so we got to be very, very careful in terms of what was the status of Mr. Pedro as his relationship.
But Mr. Pedro, whether or not he was wrongfully discharged has already been decided.
Counsel,
Yes.
I believe your time
Thank
is
you.
up.
Time.
And for all the reasons in our brief, we
Time.
hope that
They
you
are
affirm the
time
judgment.
employee.
Thank you.
I think I get a bit carried away, and it's a good thing that I have my illustrious colleague here to remind me as to the time element. I get caught up with these things. So you had reserved 2 minutes?
3 minutes, Your Honor.
Yeah, 2 minutes, all right.
3.
Let us get your best punch.
Okay, I'll do that. So for starters, the only issue before this court is a question we raised on the constitutionality of the award of punitive damages. No other errors have been brought before this court for it to address. That's number one.
I get that because you said that
Right.
that's the first thing you said in your opening.
All right. So the second punch I want to take it at this issue, Your Honors, is that the issue, I think it's so significant that we look at the award by the verdict. I mean, by the jury on the verdict. 0, 0, 0, 0 for past emotional distress, 0 for future emotional distress. How, in God's heaven's sake, can you actually balance that to $275,000 award on punitives when?
Well, let me ask you this. So you are questioning if you don't have emotional damages, you don't have physical damages, how did the jury arrive at $275,000 in punitive damages when, in fact, the whole idea of punitive damages is that when your conduct is so outrageous, reckless indifference to the rights of others, and he doesn't seem, or as I understand you, he doesn't seem to have suffered any emotional damages or any physical damages, and therefore this $275,000 is outrageous.
In fact, don't take my word for it. Take the jury's word for it. They heard him testify, they heard the testimony, and at the end of the day, their position simply was, you know what? You didn't suffer any harm. You didn't suffer any emotional distress. We're not awarding you anything. So how do you
Counsel,
balance
do
that?
do you have to suffer? Isn't it based upon the outrageous conduct of the company?
I think
One need not suffer from any physical or perhaps not even mental for it to be punitive. Isn't that correct?
you have a point in that, Your Honor, but I think that's part of the totality of circumstances that have to be taken into consideration, such as the fact that if we look at 234 of the joint appendix, it brings us back to the fact that this job, he wasn't looking for it. He wasn't requesting it. His testimony, when truthfully, I wasn't looking until Morales tells me this guy was hiring. So the jury takes his testimony, right? The rest of the testimony together, they make a determination he didn't suffer any harm. You're absolutely right, Your Honor. He didn't suffer any harm, but let's put that together with the fact of what conduct by by the appellant was reckless, with malice or deceit, that needed or required penalizing the wrongdoer in order to make an example of others. Not placing him on the schedule, it doesn't rise to that level, Your Honors.
Pardon me?
It doesn't rise to that level of awarding $275,000.
So what is an appropriate remedy? Because you're asking the court to correct what you think is an excessive award for punitive damages. What would be an appropriate remedy in this instance?
Your Honor, I would respectfully refer to the U.S. Supreme Court, the matter of Haslip, in which it indicated that any ratio over 4-to-1 is deemed to be excessive. So in this case, again, we're not questioning that was awarded or putting into question. It's just again, the amount. Our submission to you respectfully is that it should be no more than 4-to-1 over the compensatory, which is 25.
But doesn't that go by a case-by-case basis?
It goes by a case-by-case basis, absolutely. That's why it's so significant in this case to take into consideration the finding by the jury of the 200 awards on non-economic, which we can compare it to Haslip or any of the other cases B&W cited by counsel.
That your time has expired.
It has, Your Honor.
Yeah. All right. Thank
Thank you.